Okay, welcome everyone to this exciting American IRA presentation titled The 5 Mistakes That Most Investors Make with Their LLCs. I'm Sean McKay with American IRA, and per usual, we like to bring on guests that are frankly much more intelligent than I am and are experts in a particular field, and today is no exception. Today we have with us Ryan Hatley from the Sperry Law Firm. Ryan, thank you so much for joining us.
Thank you, Sean. I don't know about more intelligent, but I appreciate it.
No, absolutely. Yeah, so this will be a great discussion. Obviously, Ryan will be covering the LLCs and making sure that we're operating those things correctly. I do want to make sure that we're clear, and we'll try to say this a few times throughout the presentation. We are not today talking about IRA or 401k LLCs. So these are just simply the typical LLCs with individuals as members, and that's the broad topic that Ryan's going to discuss today. So again, this is really not related at all, frankly, to self-directed retirement accounts. Specifically, I think this is just a great topic that for investors we need to be aware of and make sure that we're operating those LLCs correctly. So the format today is the first 10 or 15 minutes we'll be going through just some very fundamental aspects of self-directed retirement accounts, as we see that a lot of the attendees and the registrants are not currently self-directed IRA clients, so want to make sure you understand the baseline of our service at American IRA. And then we'll turn it over for the main event, which is again Ryan Hatley with the Sperry Law Firm. Also, please keep in mind we do have a questions box, so feel free to type those in throughout the presentation. Realistically, we probably will not see those in live time, but we will be happy to answer those at the end of the presentation, and presumably most of those will be geared towards Ryan and the LLC concept specifically. So again, thank you all for joining us today, and hopefully you feel like you get some value out of it. So when we talk about retirement accounts, just broadly in general, I think one of the things that's really interesting and exciting about the self-directed IRA world is just simply the ability to make individuals aware of all of the options that they have available to them with their IRAs and 401ks. So as you look at this slide, you can see that certainly even just in the traditional space of working with a financial advisor or having an account just simply with a bank, there are a lot of different directions that we can go as investors. We can invest in what I consider kind of defensive products such as CDs, money markets, to some degree bonds. And then there's also more aggressive products where we're looking to really grow our money with stocks and mutual funds and ETFs and different products like that. Some people would put gold in that category. Others see that as a defensive product. But ultimately, there's a lot of opportunities for us with our retirement accounts. And so today we're going to kind of broaden that perspective, because certainly with these self-directed accounts that we'll discuss, you can invest in these sorts of products. But to be quite frank, the real benefit of self-directed accounts is investing in a different group of assets, what are considered alternative assets. So when we say the term self-directed retirement accounts, I want to make sure we're understanding two fundamental concepts. The first is that, as the name indicates, this is self-directed, meaning that you as the account holder are making investments decisions for your retirement account, your IRA, your 401k. So this is different than working with an advisor who may sit down with you, do an analysis as to what you're trying to accomplish, and then make suggestions for your portfolio. This is self-directed. You are identifying the investments that make sense for your retirement account. Now, the second concept is that when we're talking about a truly self-directed account, again, you can certainly still do stocks, bonds, and mutual funds with us, but the real benefit is going to come in the form of different assets, such as the direct ownership of real estate. Sometimes that is being a debt holder, a bank, if you will, for other entrepreneurs or investors. You can also invest in privately held companies, so companies that are not publicly traded on different markets like the NASDAQ, for example, the Dow, and precious metals, so physical gold and silver can actually be owned by your retirement account as well. And that's certainly not a complete list, but just so you get kind of the flavor of what we're talking about. Now, at American IRA, we are what's considered a fully integrated, self-directed company, meaning that we have the same ownership group for our administration company, American IRA, as we do for New Vision Trust Company, which is our custodian. That's the trust company, and that allows us to be in existence. Really, the only reason that is relevant to you as a client or a potential client is that companies that are just simply administrators that have to rely on outside resources for their trust services are very vulnerable, because that trust company can tell the administration company at any point, hey, you have 30, 60, or 90 days to find a new trust company. We're no longer carrying this line of business. And if they're unable to find that, they're actually out of business. So our principal, our CEO, our founder, Jim Hitt, he did a brilliant job of constructing this kind of multi-layered entity, if you will, so that we are, again, protected, so that our clients know that we'll continue to be in business and we don't need to find additional trust resources in the future. Now, we are never going to be Bank of America in terms of the size of our company. We have over 400 million in assets under administration. So certainly we've done a nice job of just nice, slow, steady growth. But again, we're not competing with those kind of traditional banking resources, because we do have a very different product with these alternative assets that the Wells Fargos and the Bank of Americas are not interested in administering. Now, I could spend all day telling you about why I think American IRA is a unique and, in my humble opinion, a superior resource for your self-directed needs, but I'll just give you a quick bullet point or two. Our fees are really extraordinary in the self-directed arena. Typically, you find that providers are charging you more money each year as your account balance grows, and that can be upwards of $1,800, $2,500 that you're paying for annual fees. With American IRA, our IRA annual fee tops out at $285 a year, and for the solo 401ks, which is a really unique product, that annual fee tops out at $585 a year. So really, really cost effective, and I think that we're also unique in that we're investors ourselves. We certainly are out there always learning about the technicals of these retirement accounts and adding value to our clients. But I think there's a deeper understanding when you realize that our team consists of people that are also making these investments as well. So it's not just theoretical knowledge we have. We are also one of you. We are self-directed investors. So ultimately, again, I just wanted to touch on those things very briefly. Now, when we use the term self-directed, I think sometimes there's a little bit of confusion that you're somehow going to have a totally different retirement account with us than you would have with your advisor or your banking institution currently. And that's not typically true. If you have a traditional or a rollover IRA with Wells Fargo, for example, and you decide to move even just a portion of that to us at American IRA, you are still going to have a traditional IRA. Again, self-direction, that self-directed IRA term, it's really more of a marketing term than the account changing forms or being different in some way. So any account can be self-directed, whether it's a Roth IRA, a traditional, a SEP, a simple, 401ks, these can all be self-directed accounts. And as I said, typically they're coming over to us in their same form. So you'd have that Roth IRA with us, that SEP, whatever the case may be. And as I alluded to a moment ago, keep in mind this is not an all or nothing proposition. You may simply decide to move just simply a portion of your existing IRA or 401k to us for a investment with American IRA. Now, as we look at the options and we dig a little bit deeper into what's available, when you look at the real estate asset class, any type of physical real estate can be acquired by your self-directed IRA or 401k. So whether it's raw land, condos, townhouses, single-family houses, commercial buildings, apartment buildings, industrial buildings, all of these assets can be directly owned by your retirement account. The account can also be, as I mentioned earlier, the bank and be the lender for many times other investors. And depending upon the state you live in, that's in the form of a trust deed or a mortgage to secure your money by a piece of real estate, if you will. Now, we also have clients that like to get involved in larger deals, sometimes called syndications, where the retirement account is going to be one of many owners that will own an apartment building, or maybe it's an LLC that's going to be a lender to other investors to acquire properties. And so a retirement account can be a member of a single member LLC or a multi-member LLC. And again, please keep in mind that Ryan today is going to be discussing just individually owned retirement accounts, or excuse me, individually owned LLCs. So Joe Smith is a member of ABC LLC, and he's going to add a lot of value to that conversation. So the LLC discussion today will not revolve around IRAs or 401ks. Now, as you look at the real estate asset class, that's certainly one of our more popular investment strategies that we see from clients. The key thing to keep in mind is that the retirement account needs to be making an investment. So it can purchase a property that is typically going to be utilized for one of these concepts, which is either being a rental property, doing a fix and flip. For those of you that are maybe more advanced investors working off-market deals, you might be wholesaling or putting options on properties. Those situations can also be executed with your retirement account. And joint ventures is really just, again, the retirement account being one of multiple owners for a particular investment that is being made. And then private lending, sometimes called hard money lending, is really just the idea of the retirement account being a lender many times for other real estate investors. So as you look at the process, I'm a visual guy, and I think that this is just a nice, easy, clean slide for you to understand that the IRA or 401k is going to use its capital to purchase a, again, single family house, apartment building, whatever the case may be. And as that property throws off income, whether it's rental income or profit from the sale of that house or apartment building, the money flows back to the retirement account. Because keep in mind, the retirement account is the owner of this asset. It's not you, it's not your LLCs, it's the retirement account itself. Also keep in mind any expenses that need to be paid for from the ownership of this piece of real estate would need to be paid for from the retirement account as well. So property taxes, hazard insurance, repairs, etc. will need to be paid for either by the cash flow or proceeds in the retirement account. So really that's all we have today. Again, just kind of a brief overview for self-directed accounts. Again, as we mentioned, a lot of you that are attending this are not currently self-directed account holders. And so today, again, the main event is Ryan Hatley with Sperry Law Firm. And so he is going to discuss with us the LLC concept and hopefully keep us out of trouble so that we're operating these properly. Ryan, you with me?
Yes. Thank you, Sean, for going over that and introducing me again. Again, my name is Ryan Hatley. I am a North Carolina attorney. I am an attorney with the Sperry Law Firm. We are located in South Charlotte. We do real estate transactions and business law, and we have attorneys licensed in both North and South Carolina. So we do real estate closings and other business formations for clients in both of those states. That said, I'm going to focus my discussion a bit on how LLCs are used in real estate transactions. Of course, you can use an LLC for almost any business imaginable. You can use it to buy and sell chicken and so on and so forth. But I'll talk about how it's used in a real estate deal. One of the biggest areas that are going to start impacting real estate closings for an LLC is this is a rising amount of what we call LLC fraud. If you've done any real estate transactions regularly, you've probably heard that over the past 5 to 10 years, the largest growing area of fraud in real estate transactions was wire fraud. While that's still a big deal, the next biggest growing area seems to be LLC fraud. And what that is when, for example, an LLC purchases a piece of property and then somebody else files some documents claiming to be the operators of that LLC, goes under contract and does business as that company or says they're doing business as that company. That said, closing attorneys and other attorneys in these type of transactions have been warned repeatedly by their errors and omissions of insurance companies and title insurance companies that we really need to start verifying LLC information in every deal, even in transactions where we think we know who we're working with. So that's just something to be aware of, and just another reason to make sure that you have everything ready to go with your LLC's records when you get to the closing table. Ready to work. So the title of this presentation is the 5 most common mistakes with LLCs. I'll go over those briefly and then sort of get into the meat of the presentation. Now, I see a lot of LLC business, and the first thing I see is a common mistake is people don't properly set up their LLCs. They'll do the registrations with the state that they're doing business in, but you don't set up an operating agreement. You don't do resolutions if you're working with multiple partners. And so when we get to doing a real estate transaction, you either have to rush to get those documents ready, or there's a delay. A second common mistake I see is particularly when we're working with LLCs about the time they want to start doing taxes, or the time that they're looking to do some sort of disbursements out of the accounts, is that they're not keeping records. So that's the second biggest mistake I'm seeing, is that even with a single member LLC, it's very important to keep financial records, receipts, copies of funds coming in, settlement statements, copies of your disbursements out to the members. The third mistake that I see a lot, and this ends up causing big headaches for folks, is that you're not planning when you enter into a multi-member LLCs. You're not planning for what happens when you're ready to close down the business, or if something happens to one of the members that you didn't expect, for example, a death or other type of incapacity. You want to make sure that in your operating agreements that you set up what happens if one of your members can't do business with you anymore, if they go out of business, if they go bankrupt, or if they pass away. You want to make sure that there's a plan in place so that you can keep operating your LLC while their issues are being resolved. You don't want that to slow down the work that you're doing. Fourth, I've seen this more times than I think that I would think I would, but it's not using your LLC or not using it properly. I ran into a few clients who I know that I've set up LLCs for, who will buy properties and sell properties in their personal name, worse yet, they'll buy a property in their personal name and then lease it with the LLC as the owner. So what they're doing there is they're creating additional liability for themselves. So make sure that if you have an LLC for your real estate transactions, that you're using that LLC to operate your business and putting the name of the LLC in all of your business documents. And lastly, this one is a significant problem because it really puts a risk at ruining the protections that an LLC gives, is that you have to make sure that you're keeping all of your LLC business separate from your personal expenditures. Even if you have multiple LLCs, make sure that you're keeping separate accounts, separate ledgers for each one. You have to treat it as something different. If you start commingling assets, then if a judgment comes along, you're making it an easy case for that creditor to get to your personal assets, which makes it sort of defeats the purpose of an LLC. Now that we've gone over the sort of the 5 mistakes that I see a lot, I'll start getting into the main part of the presentation. And first, so what is an LLC exactly? So an LLC is a limited liability company. It is a relatively recent invention when it comes to entities. When I say recent, I mean in the terms of the law. Recent, I think they're about 30 to 40 years old in most states. So what a limited liability company combines the tax benefits of a corporation or a shareholder and the management components of a partnership. So if you have 2 people who want to go into business together but want to limit their own exposure to judgments or other creditors, you could do a corporation. But a corporation gets taxed and the disbursements to the shareholders get taxed. So another way to do it would be a partnership. But a partnership doesn't have the type of liability protection that you want from a corporation. If one of your partners engages in business and there's a judgment against that person, it affects the entire partnership and then the partners themselves individually. So that's where the limited liability company comes into play. It gives you the tax and benefits of the partnership so that you don't have that double level of taxation. And it also gives you the liability protection of a corporation. So if there's a judgment or other lien against the company, it doesn't impact you personally. A limited liability company consists of members. Members are the owners of the LLC, and members can also be the managers. You can also have a manager who is separate from the membership group. That manager is responsible for operating the business. An LLC is formed in the state where you do business in. Most states require that if you're doing a significant amount of business, that you register your LLC there, even if it's not where your business is registered at. For example, it's common to register an LLC in Delaware or the place where you live. Here in the where I work in the Charlotte region, it's very common to see real estate investors doing business in both North and South Carolina. You want to make sure that your LLC receives title to the properties that you're doing business with, because the LLC is a separate legal entity from yourself. much like a corporation would be. So it can own property, it can own, have its own bank accounts, and probably the most beneficial part of an LLC outside of the tax and liability benefits is that it's the most flexible form of management available. There are very few things that you can't do with an LLC a management arrangement or operating agreement. Almost anything that you want to do, you can agree to do with an LLC. And finally, limited liability companies or LLCs, when they dissolve, and then you have to wind up the business. So if you have a short-term limited liability company for like one or two projects, once you're completed with those projects, you'll go through a dissolution process and then winding up the operations of the LLC. There are two main types of LLCs. Now, of course, there are dozens of different types of operating styles, but the two main types that we encounter are member-managed LLCs and manager-managed LLCs. A member-managed LLC is when the members themselves, who are the owners of the LLC, all operate the business. They are all entitled to management of the company. So, for example, if I had an LLC with 3 members in a member-managed LLC, each one of those 3 members would have a say in how the LLC does business. And they would have to approve any actions by the LLC. So that's where you start seeing things like resolutions. If you do a real estate, if you have a member-managed LLC and you're doing a sale of a home, of a property, you're probably going to be asked to provide a resolution approving that sale with a member-managed LLC, or all of the members will have to sign the documents. The second type is a manager-managed LLC. This is where the members elect to appoint a manager to operate the business. Now, that manager can also be a member, but it doesn't have to be. And the manager then, depending on the operating agreement's limitations, can then operate the business without needing the approval of other members. So, for example, if I have a 3-member LLC and one of the members is appointed a manager, that manager can then operate the business, sign documents on behalf of the business, purchase and sell real estate without having to get the approval of the members. The state that I'm licensed in, North Carolina, the defaults to a member-managed LLC if there is no other operating agreement. And that means that all of the members are, in effect, managers. I touched on this a bit already. The managers of an LLC and the members of an LLC are not necessarily the same people. Members of an LLC are the owners. The members of the LLC should be identified in the registration documents and in the operating agreement, but they do not necessarily have control over the day-to-day operations of the LLC. The managers of the LLC are the operators of it. As I mentioned before, they do not have to be a member, but they must be appointed by the members and identified in either a resolution or an operating agreement. So if you're taking on the role as the manager of the LLC, be prepared to have that paperwork available to show other individuals that or companies that you're doing business with that you have the authority to act in that role. When setting up your LLC, the first step is to file a registration with the state that you want to do business in. Different states have different advantages. Some states charge a annual fee. Other states charge a registration fee, and some states even charge a fee to register a foreign LLC. And so if you do business in multiple states, it's a good idea to get an idea of what the fees are for each one before you decide where to do your registration at. The second step is to make sure that you set up separate accounts for your LLC. You want to set up a business account, and as I discussed in the 5 most common mistakes, you should never deposit any LLC receivables into a personal account or into an account that's not for that LLC. Sometimes I see limited liability companies who are either owners of other limited liability companies. It's important then even to make sure that you're not depositing a closing check for ABC LLC into an account for XYZ LLC, even if XYZ is the only owner of ABC LLC. And again, the reason to maintain that separation is because if you don't do that, you're giving up some of that protection that an LLC offers to its members. If you treat the LLC's business as just an extension of yourself, then courts will allow creditors or plaintiffs to access your personal accounts if they see there's evidence that you're using the LLC as in a way that isn't fully separated from yourself. Now, of course, that doesn't prevent you from making disbursements to yourself once everything is done with the LLC accounting, but make sure that you're not, again, depositing any receivables for the LLC into any other accounts. When you do business as your LLC, again, it's very common for us to see single member LLCs. It's always important to make sure that you're doing business in the name of your LLC and not yourself. If you enter into a lease with a tenant, make sure that on all the documents you're identifying the LLC as the landlord or as the responsible party. With insurance documents that you have, make sure that everything is in the name of the LLC and not yourself individually or the name of another company that you may own. And the problem with doing that is that, an example I gave earlier is that, for example, if you own property in your individual name or in the name of your LLC, but you have a tenant with a lease and you're identifying the opposite on the LLC, on the lease, you've just doubled your liability. So if that tenant has an issue with you, falls and breaks their neck going down your stairs, they can sue both you and the LLC because you've identified yourself as the landlord, but the LLC is what in fact owns the property. So make sure that you're being consistent anytime you're doing that. Same thing with contractors. If you're doing a fix and flip, if the LLC owns the property, make sure that you're doing business with the contractors in the name of the LLC. That way they don't have the ability to come against you personally because you signed an invoice in your individual name, or you signed a proposal in your individual name. So when to make sure you're doing that, anytime that you're signing something, even if it's a contractor's estimates or some other paperwork, make sure that you're always identifying your role. You know, you're signing as John Doe, manager, or if the LLC's name isn't anywhere on the document, make sure you put John Doe, manager for ABC LLC. That way you maintain the separate protections available to the LLC, and there's no confusing that. Keep in mind that if you don't have it clearly laid out in your operating agreement, some states require that every member or every manager that's identified sign all the paperwork that's associated with any business the LLC does. So plan for that. Make sure that you're identifying who can enter into contracts on behalf of the LLC and who can work with contractors or take on debt for the LLC. You don't want to be in a situation where your 5-member LLC has to get everybody together to sign paperwork at a closing because we didn't plan for that in advance. And speaking of closings, so when you get ready to do real estate transactions in the name of your LLC, whether it be as a purchaser, a seller, or a lender even, you should be prepared to provide some documents to the closing attorney or settlement agent. And again, our E&O insurance, our professional liability insurance companies, and title insurance companies have all been stressing to closing attorneys the need to make sure that we are verifying this information prior to closing. In the past 3 months, I've gotten 4 reminder letters and emails from each one of those companies to make sure we're doing this. Again, that's because there is a marketed increase in LLC fraud, and so the title insurance companies want to make sure that they're not insuring something that's going to lead to a claim for them. And of course, closing attorneys don't want to do anything that's going to lead to a claim for them either. So just be prepared. You know, we don't always get to choose who we end up working with, particularly on the seller side. So make sure that you are prepared with these types of documents. So to the closing attorney, provide your articles of organization and any amendments that have been made to it. Make sure that you've maintained good standing with in existence with the state where you're registered at. You know, for example, like in North Carolina, you have to pay an annual fee. If you miss the annual fee, your company can be suspended or administratively dissolved, and that could really hamper what you can do until that's cured. So make sure that you do maintain that standing with your state. Also provide your operating agreements and any amendments, particularly if you're a multi-member LLC. You know, if you're a single-member LLC, this may not be asked of you, but if you do have more than one member, provide those operating agreements and amendments to the settlement agent. Operating things to keep in mind is that your operating agreement should clearly set forth who has the authority to sign for your company. Otherwise, we're going to default to having everybody sign. If there's no operating agreement, some states either require everybody to show up and sign the documents, or to provide an affidavit or resolution. An LLC affidavit would say that there's no operating agreement and it has to be signed by all the members. You can also have a one-time resolution put in place, again, must be signed by all the members, that says who has authority to act for the company in that transaction. Foreign limited liability companies are limited liability companies that are not registered in the state where they're doing business. So, for example, if you had a North Carolina LLC and you wanted to purchase property in your LLC's name in South Carolina, you would be a foreign LLC for South Carolina's purposes. Most states generally do not require a certificate of authority or separate registration in their state for you to do most of the business that you're going to do. Simply to sell, lease, or mortgage or purchase real estate doesn't require that separate registration. But if you find that what you're doing ends up being more of an ongoing type of business, like if you're owning a property management type of company, or you are going into a multi-use development or a multi-family residence, you may need to do that certificate of authority and consult with a local attorney when trying to make that decision. It's not a big burden. Some states don't charge a fee, and some states don't even have a process for doing that. North Carolina and South Carolina do. So if you find out that you're doing a lot of business, or you're doing some sort of ongoing long-term project, those states may require you to obtain a certificate of authority from them. And again, to the closing attorney, please provide your articles of organization and your operating agreement. But the laws of the state where you are initially registered are going to be what control your LLC. So, for example, if you are in a state that allows any member to act as a manager for the LLC, then it's going to be that state's rules that apply to your transaction, not necessarily the rules of the state where you are doing business. So after LLCs have completed their designated duty as part of your business, you may choose to dissolve the LLC. Particularly if you have to pay an annual fee, once your LLC is done with whatever it needs to do, you should dissolve it. A dissolved LLC that is voluntarily dissolved can do a few things after the dissolution paperwork is filed in order to do what's called winding up its affairs. For example, you can still sell real estate, but in those types of circumstances, your operating agreement no longer has as much control. You're going to be required to have the members and managers sign those documents once you're in that dissolution period, absent some sort of other special resolution by those members or managers. There's also administrative dissolution. This is when the Secretary of State of the state that you're registered in, or some states use another officer. This determines that you're no longer in good standing. You either didn't file a required annual report or pay your annual fee, and so they will send you a letter warning you of this, and if you don't respond, you're going to be administratively dissolved by that state. This will mean that you can no longer do business until you are in good standing. You're not required to do a reinstatement in order to sell property in that case, but you cannot purchase property, own anything, or carry out any other type of business while you are administratively dissolved. You'll have to arrange for reinstatement, which typically means paying a fine and then any back due fees and filing any reports that have been missed in order to do any new business. I put an asterisk next to the surviving managers just to remind myself really to go over what happens or what can happen if there's something unexpected that happens to a member of the LLC. And this is why it's important to have a very thorough operating agreement. I've been involved in a couple of transactions and cases where a member of an LLC unexpectedly passed away or died. If you don't have a plan in place within your LLC for that type of succession, then that ownership interest that member had is going to go to their heirs. It'll be their children, their spouses, and those folks become members of your company with a proportional share of whatever they inherited from from the decedent. Oftentimes, this can put a real halt on any business that the LLC can do, because you're going to have to get approval of those. Unless you already have a operating agreement that deals with this, you're going to have to get approval from those folks to continue to do business, to do any new transactions. And if it happens that one of the people who have inherited a share of your LLC is a minor, you may not be able to do business for 6 to 9 months. And that could put a real halt and really make your LLC no longer profitable. So make sure that you plan for that. Make sure you have some sort of either succession agreement in place where the members where the heirs of the member who is deceased either have a separate type of membership or ownership. Just make sure that that is well laid out. And, our firm will be happy to help with any type of operating agreement like that, or discuss it with an attorney that you're comfortable with the state that you do business in. And the same sort of plan should be put in place in the event that you have a member who no longer wants to do business as part of the LLC. For example, they want to cash out, so to speak. Make sure you have some sort of arrangement in place, because you don't want your business to come to a halt because of a dispute like that. And that is that's all I have for the presentation portion. Of course, I'll be happy to answer any questions about that generally when we get to the Q&A part. But that's it. I'll turn it back to Sean.
Awesome. Great information. Really appreciate that, Ryan. And again, just to kind of wrap it up, especially for those of you that are not currently self-directed investors, please keep in mind before you're out there identifying investments for your portfolio, please make sure that you're first opening and funding your account with your self-directed provider. Hopefully that is American IRA. You're then out there identifying the rental property, the investment into the privately held company, whatever the investment may be. And then at that point in time, you want to have a discussion with your self-directed company so that they can assist you with the paperwork for the purchase of the asset. And then ultimately the end conclusion is that your IRA or 401k actually owns the property, the private stock, the precious metals, whatever the case may be. So again, a big thank you to Ryan Hatley with the Sperry Law Firm. A lot of great meat and potatoes information. I wanted to remind everyone we do have the questions box, so this is a great time. If you have not already typed in your questions, please feel free to type those in. Again, presumably those will probably be for Ryan and the LLC concept. And again, I'm Sean McKay with American IRA. So for those of you interested in discussing self-directed concepts more, our headquarters is in Asheville, North Carolina, and that number is 828-257-4949. And if you're needing a toll-free number, that's 866-7500-IRA, which is 472. And again, fantastic information from Ryan Hatley with the Sperry Law Firm. You can reach Ryan at the information below, which is rhatley@sperrylaw.net. Their website is sperrylaw.net, and the number is 704-544-7003. So we'll just hopefully, and again, we appreciate Ryan being willing to give us a few minutes of his time post conversation, which obviously for those of you that have spent time with attorneys, you know that this is incredibly valuable in a lot of ways, certainly informationally, and just how much this is actually frankly saving in terms of attorneys' fees. So definitely feel free to ask a question if you have it. So the first one is, can an E-Trade account be converted to self-directed? So essentially, if you have stocks, bonds, mutual funds, essentially an online brokerage account, you will need to actually liquidate. So put those positions into cash, at least for the portion that you're looking to move to a self-directed provider. So you essentially would need to sell some portion of those assets to liquidate that and be able to move those to another alternative asset-based firm. So thank you for that question. The next one is, how do you add protection for a personal loan on a rental property, Ryan? Does quick claiming to business add that protection?
So I imagine this is a situation where the individual has a personal loan in their own name, and they want to make sure that the property is not subject to any collection efforts. If that's the case, then yes, initially you can deed the property over to the limited liability company. Just keep in mind that efforts to avoid judgments and claims can be unwound. So if you already have a pending lawsuit about this, or that's already been started, you may not get that protection. The plaintiff would have to go through some additional steps. So it doesn't mean it's not worth trying, but it's not a guarantee.
Perfect. Great. Thank you. So the next question, Ryan, is, if you are the only member of the LLC and you only have yourself listed as member, does it need to be updated to reflect manager as well?
So that answer depends on what state that you do business in. In North Carolina, where I'm licensed, and in South Carolina, where our firm does business, you do not need to change anything if your registration documents list yourself as a member, because in those states, the members are presumed to be managers unless your operating agreement says otherwise.
Perfect.
So if it's a state other than North or South Carolina, I'll have to defer to, I guess, ask an attorney in your state. But
Absolutely, and you know, certainly we appreciate Ryan being willing to field these. As he mentioned, it's tough because so many states are different. So, you know, there's just a lot of these aspects where there's a lot of unknown aspects of how this will flow and what have you. So, thanks for giving us essentially as much as you can as an attorney for a specific region. The next question is, how do we get the slides emailed to us? So certainly if you're listening to this live, then you registered, and so we will be sending out the recording for that. So if you would like the actual PowerPoints themselves, other than just the recording, feel free to email us, and we'll be happy to get you the PowerPoint slides as well. And if you want those slides, probably the easiest way to do this is we'll send that directly to Michelle Tracy, who heads up our marketing department. So that's Michelle.Tracy, Tracy, at AmericanIRA.com. So the next question is, can an inherited IRA be changed to self-directed? And would there be fees and taxes? So yes, inherited IRAs can be moved to self-directed accounts, and essentially they will stay in their same form. So for example, if it's an inherited traditional IRA currently, you would also have an inherited traditional IRA with us at American IRA. That will not constitute a taxable consequence. In terms of fees, there is a $50 setup fee to open the account. The annual fee of $285 will be charged when you make your first investment with us, not when the account is set up or funded. So just be aware of that, and we're happy to discuss all the particulars with you. If you're interested in calling or emailing us, I'd love to discuss that further. So thank you for that question. The next question is, can I set up a self-directed Roth as a retiree, but we'll be doing real estate investing for profit? So certainly Roth accounts can be set up. The key there is that the individual needs to have earned income, essentially. So a 5-year-old that is a model, for example, can have a Roth IRA, and someone who is 105 years old can have a Roth IRA if they have earned income. So earned income is the key to have the ability to either start a Roth or to make a contribution to a Roth. So thank you for that. So Ryan, the next one's for you. Quick claim deed property from personal name to LLC that has a HELOC on it. Will the due on sale clause be enacted?
So we get this question quite a bit, of course, because folks want to buy properties, but they can't get a loan in the name of their LLC, so they buy an individual name and then want to deed it afterwards to their company. The answer is technically yes. The bank can choose to call the loan due on the transfer of the property. There are some protections about doing that with regards to a trust, but not so much with an LLC. That said, I don't know that I have ever witnessed or heard of a company, a bank actually doing that. So long as they're still getting paid, they're not going to go through that process just because you moved it over to a single member LLC in your name. But they could. Again, that said, I've not ever seen it done.
That's fair. That's fair. Do your self-directed IRAs offer checkbook writing? So the short answer is yes. With American IRA, you can have checkbook control or an IRA or 401k owned LLC. It is not mandatory with our firm, but it is an option for clients that are interested in doing that. All right, so Ryan, if I already have rental property not in an LLC, can I set up LLC and transfer in the properties?
Yes. Yes, you can. You just do a deed from yourself and any other owners to the limited liability company. You would then, if you already have leases in place, you can assign those leases to the limited liability company and change over any insurance policies or other types of agreements that you have related to those rental properties just to be in the LLC name. But yes, you can go ahead and do that.
Great. And just two more here. So on earned income, can it be profits from a real estate flip? And so this is kind of a continuation from the question, I believe, regarding the ability to contribute to a Roth IRA. So technically speaking, this is where a CPA is going to bless the earned income aspect. If it's a real estate flip, and by that I'm going to assume that it was a purchase, it was fixed up, and then presumably maybe a couple of months later it was sold to a third party. That's usually going to be considered essentially earned income. That's active activity. That's kind of typically considered a trade, real estate professional type of activity. So I am not absolutely blessing this, but many times CPAs will deem that to be earned income, which would then qualify you to be able to contribute to a Roth. So again, short answer is talk to your CPA, but probably will be considered earned income. Thank you for that. And then Ryan, last one. So how can you put an LLC in a trust?
So the way to manage an LLC in a trust agreement is to make the membership interests of the LLC assets of the trust. So, for example, if you have an LLC that does business, buying and selling properties, then you would have the member of the LLC be the trust. So if you have if it's a single member LLC, you just set up a few documents to transfer the membership interest to the trust and keep those records with your LLC documents.
Fantastic. All right, a lot of great questions there. Certainly sounds as though some of you may be reaching out to Ryan, scheduling some time to work with him, either on real estate closings or perhaps constructing some entities like an LLC. Again, really appreciate it. Ryan Hatley with the Sperry Law Firm. Thank you so much for the information, for the great content. Any parting thoughts, Ryan?
No, thank you for having me, Sean. I appreciate it, and I look forward to doing it again sometime.
Absolutely. So again, everyone, thank you so much, whether you're listening to it live or on the recording. Also, please feel free to reach out to us and let us know what sort of content you're interested in for future webinars, live events, whatever the case may be, so that we can find the best resources and deliver that content to you. So thank you all so much, and have a great day.